Think love conquers all? Not when legislators get involved. Across centuries and continents, governments have appointed themselves the unwanted chaperone at humanity's most intimate moments, armed with rulebooks that range from bizarre to genuinely disturbing. These aren't just dusty legal relics. Many remain enforceable today, turning romance into a minefield of permits, age requirements, and inexplicable restrictions on facial hair proximity. What follows is a journey through matrimonial madness, where the bureaucratic meets the absurd, and where saying "I do" sometimes requires presidential approval, genetic audits, or proof you've successfully murdered the correct number of crows. 1. The Saudi Marriage Audit. Romance in Saudi Arabia comes with a comprehensive background check that would make intelligence agencies jealous. A Saudi man seeking to marry a foreigner must obtain official state permission through a process resembling a corporate merger more than a love story. The requirements? He must be between 40 and 65 years old, maintaining that sweet spot of maturity the government deems appropriate. Divorced applicants face a mandatory 2-year waiting period, presumably to ensure they've forgotten what went wrong the first time. The pièce de résistance, a dossier including certification from the local mayor that the groom carries no disqualifying hereditary diseases. Nothing says happily ever after quite like municipal health surveillance transforming your wedding into a compliance exercise. 2. Montana's Phantom Wedding. Montana offers something revolutionary for the commitment-phobic or impossibly busy. Marriage where neither party needs to show up. Welcome to the double proxy marriage, the only such arrangement legal in the United States. You could be stationed in Afghanistan, your partner teaching English in Tokyo, while 2 complete strangers in a Kalispell courthouse legally bind you for life. The law dates to 1889, designed for Montana's vast rural distances and military members. What began as frontier pragmatism has evolved into something surreal. A wedding ceremony as pure legal performance art, where the couple exists only as signatures on paperwork. It's the ultimate testimony to marriage as contract, stripped of every romantic pretense. 3. Japan's gendered timeout. Japan enforces a 100-day remarriage ban, but only for women. Men can divorce and remarry the same afternoon, perhaps stopping for celebratory sushi between ceremonies. Women, however, face a mandatory cooling-off period stretching over 3 months. The law's origin? A 19th-century obsession with paternity certainty in an era before DNA testing. The government essentially said, "We need to make sure any baby belongs to the right husband," then enshrined female reproductive timelines into civil code. Never mind that modern science resolved this question decades ago with a simple cheek swab. The law persists, a legislative fossil from the Meiji era, punishing women for a problem that no longer exists. It's bureaucracy's middle finger to scientific progress. 4. France's death-defying matrimony. In France, death is not considered a deal-breaker for matrimony. The practice is called necrogamy, and it requires presidential approval, because apparently, marrying deceased partners demands executive oversight. You must prove you intended to wed before your beloved's untimely departure, typically through published bans, military permissions, or wedding invitations. The tradition started honoring fallen soldiers so their pregnant fiancés could marry them posthumously, legitimizing their children. Today, Article 171 of the French Civil Code still permits these spectral unions, though 1 in 4 applications faces rejection. The marriage applies retroactively to the day before death, but comes with a catch. The living spouse inherits nothing. It's romance with all the commitment and none of the financial benefits. 5. China's mandatory reconciliation. China treats divorce like a software update, mandatory waiting period included. Since 2021, couples filing for divorce must endure a 30-day cooling-off window before finalizing anything. You submit your application, then wait a full month, during which either party can cancel the proceedings simply by not showing up to the final appointment. The government positioned this as protecting families, but it's bureaucratic marriage counseling disguised as administrative process. The state becomes an uninvited third party in your relationship's dissolution, betting you'll reconcile out of sheer inconvenience. It's governmental paternalism at its finest. Your breakup is too important to rush, unlike, say, getting married in the first place, which requires no waiting period whatsoever. 6. Monaco's royal veto power. In Monaco, citizens need more than love and a marriage license. They need the prince's blessing. When Monegasques decide to marry, notice of intent posts publicly for 10 days, during which the prince's office can formally object and shut down the entire affair. It's not ceremonial rubber stamping, it's actual sovereign power to veto your wedding based on reasons known only to the palace. Imagine explaining to your fiancé that you're calling off the engagement because Prince Albert wasn't feeling it. The tiny principality maintains this aristocratic oversight as a cultural relic, a reminder that, even in matters of the heart, some citizens remain subjects first, individuals second. Your biggest wedding threat isn't cold feet, it's royal disapproval. 7. Utah's geriatric cousin clause. Utah allows first cousins to marry, but only after both parties reach 65 years old. The alternative pathway? Both must be over 55, with a court certifying that one partner is infertile. It's the government's pragmatic, slightly morbid calculation. Genetic concerns matter less when reproductive years are decisively behind you. The state essentially declares, after 65, the genetic warranty has expired. Go for it. This isn't romantic flexibility. It's bureaucratic risk assessment applied to your family tree. 8 states maintain similar restrictions, each drawing arbitrary lines around age and fertility. The magnificence lies in the specificity. Someone in the Utah legislature sat down and thought, 65 seems right, then wrote it into law. 8. The Philippines' permanent prison. The Philippines and Vatican City stand alone as the only sovereign nations where divorce remains completely illegal. In the Philippines, your sole escape route is annulment, a lengthy, expensive, and psychologically brutal process requiring you to prove the marriage was invalid from inception. You can't simply say it didn't work out. You must argue it never legitimately existed, constructing legal fiction to escape legal reality. For millions trapped in abusive or dysfunctional marriages, Till Death Do Us Part transforms from romantic vow to ironclad prison sentence. The Catholic Church's influence shaped these laws, prioritizing institutional doctrine over individual well-being. It's a system where religious tradition supersedes human suffering, and where the only guaranteed exit is a coffin. 9. South Carolina's No Backsies Proposal Law. Proposing marriage as a joke in South Carolina can land you criminal charges. If you're over 16 and propose deceitfully, without genuine intention of following through, you've committed a misdemeanor under the state's offenses against morality and decency statutes. The law treats false proposals as romantic fraud, punishable by the state. It's governmental enforcement of sincerity, legally mandating that your bended knee moment be authentic. Imagine the courtroom scene. Prosecutors presenting evidence of your insincere proposal, perhaps citing text messages or witness testimony proving you never meant it. The state becomes the enforcer of emotional honesty, drawing a legal line between jest and genuine commitment. Don't propose unless you mean it. South Carolina is watching. 10. Delaware's jest defense. Delaware offers the opposite approach. If you married as a dare or jest, the state provides a legal escape hatch. Getting hitched as a joke constitutes official grounds for annulment. No waiting period required. You simply prove to a judge that your sacred union began as entertainment, gone catastrophically wrong. It's the government acknowledging that sometimes spectacularly bad decisions deserve immediate reversal. The law recognizes a category of matrimonial idiocy so profound it merits instant dissolution. Picture the courtroom testimony. Your Honor, I only married her because my fraternity brothers bet me $50. Delaware nods sympathetically and hands you annulment papers. It's legislative mercy for life's dumbest moments, admitting that, yes, some marriages are legitimate mistakes from conception. 11. England's harpoon wedding tradition. In Hartlepool, England, legitimate local status requires marriage over a whaler's harpoon. This isn't codified law. You won't find it in parliamentary records, but the tradition carries the weight of communal identity so powerful it functions as legal requirement. To be considered a true Hartlepoolian, Couples must incorporate this seafaring relic into their ceremony. Its cultural heritage expressed through peculiar ritual, transforming wedding planning into a quest for antique whaling equipment. The practice celebrates the town's maritime history, but also creates logistical nightmares for wedding coordinators suddenly responsible for sourcing and safely incorporating a lethal fishing implement into romantic proceedings. It's beautiful testimony to local culture and proof that sometimes tradition makes absolutely no practical sense. 12. Kentucky's three-strike marriage rule. Kentucky believes in second chances, even third chances, but draws a firm legal line at number 4. The state explicitly prohibits remarrying the same person for a fourth time. You can marry, divorce, remarry, divorce again, then complete the trilogy, but that fourth attempt gets denied at the clerk's office. The law positions government as your friend who, after watching you reunite with your toxic ex 3 times, finally confiscates your metaphorical car keys. It's legislative intervention in pathological relationship patterns. The state saying, "No, we're done enabling this." Imagine the couple facing rejection. But this time will be different. The clerk just shakes their head, pointing at the statute book. Kentucky has witnessed your dysfunction and officially refuses to participate further. 13. Greece's leap year curse. Greek couples face an enemy more powerful than disapproving in-laws: the calendar. A widespread superstition holds that marrying during leap years guarantees divorce, cursing unions from inception. While not codified law, cultural pressure is so intense that wedding venues and planners suffer massive business drops every 4 years. Imagine telling your fiancé, "I love you, but we have to wait 11 months because February has 29 days this year." The belief is so embedded in Greek consciousness that it functions as effective legal prohibition through social enforcement. Think about this. Your lifelong commitment could be damned by an extra day in February, a quirk of calendar mathematics. It's superstition, wielding power typically reserved for legislation. 14. Saudi Arabia's age gap bureaucracy. Beyond general marriage restrictions, Saudi Arabia scrutinizes age differences with mathematical precision. Large age gaps between partners trigger additional bureaucratic hurdles, requiring justifications submitted to marriage officials who assess whether the union serves legitimate purposes or exploitative ones. The system attempts to prevent forced marriages and protect younger partners, particularly women, from coercive arrangements with much older men. On paper, it's protective legislation. In practice, it grants officials subjective power to approve or deny marriages based on personal interpretations of appropriate age differences. Love might transcend numbers, but Saudi marriage law definitely doesn't. Every relationship faces an age-based audit, with bureaucrats calculating whether your romantic arithmetic adds up to governmental satisfaction. 15. Mississippi's furious anti-polygamy sermon. Some laws are memorable for content. Mississippi's polygamy statute is memorable for its sheer fury. The law doesn't simply prohibit multiple spouses, it describes cohabiting with a second partner as adultery and fornication, then launches into extended editorial about how it constitutes a disgusting offense to public decency. It reads less like legal code and more like a pastor's impassioned sermon, barely contained within statutory formatting. You can practically hear the legislator pounding the desk while drafting this one, channeling moral outrage into legal text. Most laws maintain clinical detachment. Mississippi's polygamy prohibition is a dramatic monologue, a legislative rant that somehow got codified. Its governance meets performance art, where the rule's emotional intensity rivals its legal authority. 16. Kansas's accidental marriage trap. Are you married? You might be wrong. Kansas fully recognizes common-law marriage through hilariously vague requirements. You simply must mutually hold yourselves out to the public as being married. What does that mean? Does a joint Costco membership count? Changing your Facebook relationship status? Filing joint taxes? You could accidentally wander into legal matrimony without signing a single document, your marriage status determined by public perception rather than paperwork. The law creates a gray zone where cohabiting couples risk unexpected legal binding, their relationship status ambiguous until tested in court. It's Schrodinger's marriage. simultaneously existing and not existing until officially observed. Kansas trusts social performance over formal ceremony, which sounds romantic until you accidentally become legally married. 17. North Carolina's homewrecker lawsuit. In North Carolina and handful of other states, you can sue your spouse's lover for cash damages under alienation of affection laws. Your husband's mistress didn't just ruin your marriage, she committed a tort, and you can take her to civil court seeking compensation. Juries have awarded substantial damages in these cases, forcing third parties to pay for destroying marriages they didn't make vows to protect. It's a legal framework treating affection as property that can be stolen, as if love operates on theft laws. Imagine the courtroom dynamics, presenting evidence of your broken heart, putting a dollar amount on stolen devotion, cross-examining the person who seduced your spouse. It's monetized heartbreak, where emotional devastation converts to legal liability and courtroom drama. 18. Truro's hunting qualification. In Truro, Massachusetts, prospective grooms must prove provider credentials through wilderness skills. Specifically, a man must successfully hunt and kill either 6 blackbirds or 3 crows before earning marriage eligibility. Its matrimonial qualification as avian body count, turning sacred commitment into bizarre fetch quest for dead birds. The law reflects antiquated notions of masculine provision. If you can't successfully slaughter vermin, how can you support a family? Picture the scene. A nervous groom to be stalking suburban backyards with a rifle, desperately trying to bag his 6th blackbird so he can legally propose. It's frontier logic preserved in legal amber, transforming wedding preparations into something resembling a video game achievement system. Marriage Unlocked. Crow Slayer. 19. The 1770s English make-up witchcraft law. 18th century England treated cosmetics as potential witchcraft. A law declared that women using scents, paints, cosmetic washes, artificial teeth, false hair, or high-heeled shoes to seduce men into marriage faced serious consequences. Marriages could be annulled, and the deceptive bride tried under witchcraft statutes. It was the original catfishing scandal, only instead of getting blocked online, you risked burning at the stake. The law positioned female appearance enhancement as fraudulent enchantment, suggesting that makeup didn't enhance features, it cast spells. Any woman whose husband later felt deceived by her appearance could claim witchcraft, transforming buyer's remorse into criminal prosecution. It's historical misogyny dressed as consumer protection, where women's grooming choices carried potential capital punishment. 20. Florence's cold honeymoon crisis. Florence, Italy, home to Renaissance art and bizarre public health laws, technically prohibits anyone with contagious diseases from entering the city. Catch a simple cold during your Italian honeymoon? You could theoretically be barred from re-entering Florence after a day trip. It's an ancient quarantine regulation never removed from the books, transforming common sniffles into potential immigration crisis. The law made sense during plague centuries, when disease control meant citywide exclusions. Today, it's an absurd relic where your runny nose becomes a legal liability. Imagine explaining to border officials that, yes, you have a slight cough, but please, your hotel reservation is non-refundable. Florence guards itself against the common cold with the same legal framework once deployed against bubonic plague. 21. UAE's affection roulette. In the United Arab Emirates, holding your spouse's hand is generally acceptable, but any public display deemed too passionate risks arrest for indecency. Where's the line? Nobody knows. It depends on who's watching, what neighborhood you're in, and the officer's interpretation of excessive. A sweet kiss in one district could trigger criminal charges in another. It's romantic roulette where the stakes are your freedom, your displays of affection subject to subjective enforcement that varies by observer. Married couples navigate this by performing constant environmental assessments. Are we in a conservative area? Who's nearby? Is this handhold safe or potentially criminal? Love becomes a calculated risk, each affectionate gesture a gamble against unpredictable legal consequences. 22. New Mexico's Shakespeare Protection Act. New Mexico prohibits married couples from censoring each other's reading material. Specifically, the statute was designed to prevent feuding spouses from blacking out passages in shared copies of Romeo and Juliet. Yes, really. Imagine the domestic dispute that inspired this. Heated arguments over star-crossed lovers, one spouse dramatically redacting scenes while the other calls the authorities. It's a law protecting Shakespeare from your marital drama, positioning the bard's work as requiring governmental defense against household conflicts. The specificity is magnificent. Not just any book, but Romeo and Juliet, as if that particular tragedy provoked unique matrimonial censorship battles. Its literary preservation meets domestic intervention, suggesting New Mexico once faced an epidemic of Shakespeare-related spousal editing wars. 23. China's divorce inconvenience strategy. China's 30-day divorce cooling-off period includes a strategic bureaucratic catch. If both parties don't appear together to finalize the divorce at the exact appointed time after the waiting period, the application automatically cancels. Missing the appointment means starting over. New application, new 30-day wait. The government engineered the system to maximize inconvenience, betting couples will give up and stay together rather than navigate the administrative obstacle course twice. It's divorce by attrition, where the state hopes your relationship's problems seem less annoying than refiling paperwork. The law doesn't counsel or mediate. It simply makes dissolving marriage so tedious that staying together becomes the path of least resistance. Bureaucratic friction as marriage preservation strategy. 24. Massachusetts' no-age minimum loophole. Massachusetts maintains a shocking legal gap. There's technically no minimum marriage age. With parental consent and judicial approval, a judge can authorize marriage for a child of any age, including 12-year-olds. It's a holdover from eras when such arrangements were disturbingly common, and it remains a legal possibility today. While rare in practice, the absence of a hard statutory minimum creates a vulnerability in law, a doorway to exploitation that shouldn't exist in modern legislation. Most states have closed this loophole. Massachusetts hasn't. The law trusts judicial discretion to prevent abuse, but the mere possibility that a tween could legally marry with the right permissions is a legislative horror waiting in the wings. 25. Louisiana's Napoleonic household hierarchy. Louisiana operates under Napoleonic Code, creating unique marriage law oddities. For decades, the husband was legally designated head and master of the household, granting him sole authority to sell the family home without his wife's consent. While reformed, remnants of this patriarchal structure persist in property laws, creating modern complications. The legal system still carries DNA from an era when wives were essentially dependents, rather than equal partners. Property rights, inheritance rules, and financial decision-making authority all bear traces of this original hierarchy. Its governance shaped by 19th-century French imperialism, persisting into the 21st century despite reforms. Louisiana demonstrates how difficult it is to fully excise legal traditions once they've burrowed into state code. 26. Nevada's good faith Elvis wedding. In Nevada, marriages performed by unauthorized officiants remain legally valid if at least one party genuinely believed the Elvis impersonator was qualified to marry them. The law validates matrimony based on good faith rather than proper credentials. As long as you sincerely thought the guy in the sequin jumpsuit had legal authority, congratulations, you're hitched. It's a legal framework that prioritizes intent over bureaucratic correctness. Protecting couples from discovering their wedding was technically invalid years later. Nevada recognizes that in the chaos of Las Vegas chapels, not everyone verifies ordination certificates. The law says, you thought it was real, so we'll make it real, turning belief into legal binding. It's peculiarly philosophical for marriage law. 27. Scotland's sobriety requirement. Scottish law empowers registrars to refuse conducting ceremonies if they believe either party is too intoxicated to consent. Show up drunk to your own wedding and you risk the officiant calling it off. Not your angry bride or groom, but the government official who suddenly prioritizes your decision-making capacity over your romantic timeline. It's sensible protection against impaired consent, but the potential embarrassment is staggering. Imagine the scene. Your guests assembled, the venue decorated, and then the registrar announces, "Sorry, the groom has had too much liquid courage. Wedding cancelled." Scotland treats matrimony as a decision requiring sobriety, refusing to validate unions where alcohol might be doing the deciding. It's responsible governance that turns hangovers into ceremony cancellations. 28. India's religious arbitrage prosecution. In India, a Hindu man who converts to Islam specifically to marry a second wife without divorcing the first can be prosecuted for bigamy. The law addresses a specific loophole. Hindu personal law requires monogamy, but Islamic law permits up to 4 wives. So some men attempted religious arbitrage to circumvent restrictions. The Supreme Court stepped in, declaring that converting religions purely to exploit polygamy permissions doesn't exempt you from bigamy prosecution. It's legal code closing a cultural loophole. The judiciary saying, "Nice try, but no." The ruling prevents men from treating religious conversion as a matrimonial legal workaround, prioritizing law consistency over religious permissiveness. India chose to prevent gaming the system over respecting certain religious marriage allowances. 29. Tennessee's Knowing Insanity Clause. Tennessee prohibits marrying someone officially declared insane. That seems reasonable. But the law gets peculiar. If the sane spouse was unaware of the insanity at the time of marriage, they can get an annulment. However, if they knew their partner was legally insane and married them anyway, the marriage is valid and binding. The state essentially says, you knew what you were getting into, so no refunds. It's a law that punishes awareness, making ignorance a better legal position than informed decision-making. The logic suggests that marrying someone you know is insane demonstrates sufficient commitment that government won't rescue you later. Tennessee enforces your choices, even when those choices involve matrimonial bonds with legally certified madness. 30. Michigan's hair permission law. In Michigan, a wife technically cannot cut her own hair without her husband's permission. This dusty relic from English common law, where a woman's property, including her hair, legally belonged to her husband, has never been formally repealed. Police won't raid hair salons, but the law exists as a legal fossil, a ghostly reminder of coverture laws where married women had no independent legal identity. Every Michigan woman getting a haircut is technically committing a minor legal violation if she didn't secure spousal approval first. It's absurdly outdated, yet it persists in the state code, a testament to how difficult it is to clean centuries of legislative debris from the books. A haircut once required marital negotiation. 31. London's motorcycle sex ban. London maintains a bizarrely specific ordinance. Having sex on a parked motorcycle is illegal. While not specifically a marriage law, it certainly limits spontaneous two-wheeled romance for married couples. The rule's specificity invites questions. What series of events prompted the city council to declare, "That's it, we must regulate motorcycle intercourse"? How many incidents occurred before they codified this prohibition? The law suggests a pattern of behavior significant enough to warrant legislative attention, implying that at some point, motorcycle-based public intimacy became a civic problem. Its governance as reactive solution to very specific complaints, creating a regulation so oddly targeted that it sparks more curiosity than compliance. London's legal code, addressing motorcycle sex since whenever this became necessary. 32. Sarasota's widow parachuting ban. Sarasota, Florida prohibits widows from parachuting on Sundays. Any other day is fine. Single women and married women can skydive whenever they want, but widows face a Sunday restriction so specific it feels personally targeted. It's a law that raises immediate questions. What grudge inspired this? Did a widow's Sunday parachute jump somehow offend 1940s Sarasota so deeply that legislation became necessary? The rule combines mourning status, recreational activities, and religious day observation into one bewildering prohibition. Picture the enforcement scenario. Ma'am, I see you're widowed and it's Sunday. Step away from that airplane. It's governance at its most inexplicably specific, a rule that suggests a very personal, very weird backstory that history has unfortunately not preserved. 33. Vermont's false teeth permission slip. Vermont once required women to obtain written permission from their husbands to wear false teeth. Think about that. A woman's dental health decisions were subject to spousal veto. It's another coverture relic where husbands exercised legal control over wives' bodies and possessions, extending even to cosmetic dental choices. Imagine asking your husband for a permission slip to visit the dentist, as if your mouth was his property, requiring his approval for modifications. The law reflected an era when married women had virtually no legal autonomy, their every decision filtered through male authority. While no longer enforced, it remains a hilarious and horrifying artifact of how recently women lacked basic self-determination. Vermont's dental bureaucracy, because your teeth weren't really yours. 34. Australia's habitual drunkard clause. Australian law allows marriage annulment if one party was so intoxicated during the ceremony they couldn't understand what was happening. And the law specifically mentions habitual drunkards, implying long-term alcoholism rather than one-off benders. It's the legal system protecting you from making lifelong commitments during profound, alcohol-fueled idiocy, but requiring a pattern of behavior rather than a single incident. The distinction matters. Australia won't void your marriage just because you got drunk at your own wedding once. You need a documented history of habitual intoxication for this defense. It's the government saying, we'll save you from yourself, but only if you've established a consistent pattern of terrible decision-making. Annulment for alcoholics, but not amateurs. 35. Indonesia's lustful communication laws. Indonesia's anti-pornography laws are so broadly written they theoretically prohibit any writing, sound, image, or other form of communication which has content of lasciviousness or exploitation. In extreme interpretations by conservative groups, this could include lustful texts to your own spouse. While not typically enforced within marriages, the law's language is sufficiently vague that it creates a theoretical framework where expressing sexual desire to your legal partner might violate national decency standards. Its legislation so overreaching it potentially criminalizes marital intimacy, treating spousal desire as potentially illegal pornography. The law aims to regulate public morality, but uses language so broad it accidentally encompasses private married life. Indonesia's legal code, where sexting your wife is a gray area. 36. Washington's anti-pauper marriage law. Washington state makes it illegal to marry a pauper, someone dependent on public assistance. The law was designed to prevent people from other states moving to Washington, marrying a resident, and immediately becoming a financial burden on state welfare systems. It's cold, calculating legislation that puts a literal price tag on the right to marry, treating matrimony as a financial transaction requiring adequate resources. Love might be free, but in Washington, marriage requires demonstrating you won't drain public coffers. The law positions poverty as a legal impediment to matrimony, essentially telling low-income individuals that their financial status disqualifies them from marriage rights. It's governance that treats romantic commitment as a privilege contingent on economic status. 37. Kuwait's dog divorce precedent. In Kuwait, conservative Islamic law interpretations have led to rulings where wives were granted divorces because their husbands insisted on keeping dogs in the house. The legal reasoning: dogs are considered unclean, and their presence made it impossible for the wife to practice her faith at home. It's a case where it's me or the dog had actual legal standing, with courts siding with the human over the canine. The ruling reflects how religious law intersects with domestic life, where pet ownership decisions can constitute grounds for marriage dissolution. Picture the courtroom arguments. Lawyers debating canine cleanliness, religious obligations, and whether a golden retriever's presence fundamentally violates marital duties. Kuwait's divorce courts, where dogs lose custody battles by default. 38. Wisconsin's anti-shallow marriage law. Wisconsin makes it a crime to marry for a temporary or physical purpose. The law seems to target sham marriages, but the wording is wonderfully vague. How do prosecutors prove your marriage is based on physical attraction rather than deeper connection? It sounds like the state is trying to outlaw shallow relationships, demanding you love your spouse for their personality. The law's enforcement would require mind reading, proving someone married purely for looks or temporary convenience, rather than lasting commitment. It's the government's clumsy attempt at regulating relationship authenticity, treating superficial motivation as criminal offense. Wisconsin suggests that marrying someone because they're hot is legally questionable. Good luck proving your love has sufficient depth to satisfy state standards. 39. Wichita's Mother-in-Law Protection Act. Wichita, Kansas has an ordinance stating that a man's mistreatment of his mother-in-law cannot be used as legal grounds for divorce. Imagine the family dinners that inspired this. Wives citing, "He's horrible to my mom," so frequently in divorce proceedings that city fathers had to intervene legally. The law gives explicit protection to sons-in-law who are absolute jerks to their wives' mothers, declaring that no matter how badly he treats her family, it doesn't constitute valid divorce grounds. It's legislation that prioritizes marital bonds over extended family relationships, suggesting that being terrible to your in-laws is legally acceptable behavior. Wichita decided that intergenerational family dynamics aren't the court's problem, even when they're destroying marriages. 40. Minnesota's garlic breath law. Minnesota maintains a statute making it illegal for a man to have sex with his wife if his breath smells of garlic, onions, or sardines. That's just good advice elevated to legal requirement, suggesting someone thought basic hygiene needed governmental enforcement. It's rare legal code that protects not your rights, but your nostrils, positioning bad breath as a legal impediment to marital intimacy. The law implies that Minnesota once faced an epidemic of odoriferous husbands whose aromatic breath warranted state intervention. Picture the enforcement scenario. Police investigating bedroom complaints about garlic smell. It's governance at its most intimate and absurd, suggesting that fresh breath is not just considerate, it's legally mandatory. Minnesota's matrimonial motto: brush your teeth or face consequences. 41. Arizona's bathtub donkey regulation. Arizona prohibits having a donkey sleeping in your bathtub after 7 p.m. While not explicitly a marriage law, imagine the domestic argument that inspired this regulation. "Honey, the donkey's dripping all over the bath mat again." It's a legal fossil from an era when livestock choices could cause municipal crises, suggesting Arizona households once faced sufficient bathtub donkey conflicts to warrant legislation. The specificity is magnificent. Not just donkeys in houses, but specifically donkeys in bathtubs, and specifically after 7 p.m. What happens at 7:01 that makes this problematic? The law creates more questions than it answers, standing as testament to household chaos gone legislative. Arizona addressed equine bathroom usage with formal governance. 42. Iran's subscription marriage. Iran offers temporary marriage or sigya, contractual matrimony lasting anywhere from 1 hour to 99 years. The contract specifies duration and includes dowry terms, creating what critics call a pay-as-you-go marriage system. Proponents argue it offers religiously sanctioned relationship pathways. Critics contend it's often exploited as legal loophole for short-term flings or prostitution with spiritual veneer. It's matrimony as subscription service, where commitment comes with expiration dates written into founding documents. Imagine negotiating your marriage's termination date during the proposal. Will you marry me for the next 3 years? It's the ultimate prenuptial agreement. Your divorce date is scheduled before your wedding date. Iran's legal framework treats marriage as a temporary contract rather than permanent bond, fundamentally reimagining what matrimony means. 43. South Africa's default financial merger. In South Africa, the default marital regime is in community of property, meaning from the moment you say "I do," all individual assets and debts merge into one joint estate. Your spouse's bad credit score instantly becomes your problem. Their debts, your obligations. If you want separate finances, you must proactively sign a prenuptial agreement. Otherwise, financial fusion is automatic and absolute. It's marriage as immediate economic merger, where love and balance sheets become indistinguishable. The system presumes complete financial unity unless you explicitly opt out beforehand, treating matrimony as inherently economic partnership. South Africa doesn't allow gradual financial integration. It's instant and total, turning wedding days into the moment your net worth gets recalculated to include someone else's student loans. 44. Somalia's puberty marriage exception. Somalia sets the legal marriage age at 18, but includes a disturbing exception. Girls can marry as young as 10 if they show puberty signs and give consent. The concept of a 10-year-old providing meaningful, informed consent to lifelong legal union is deeply problematic, making this one of the world's most troubling marriage laws. It's legislation that conflates physical development with emotional and intellectual readiness, treating early puberty as sufficient qualification for adult commitments. The law creates legal pathways for child marriage under the guise of consent from children who lack the maturity to understand what they're consenting to. Somalia's exception transforms a protective age restriction into a loophole for exploitation, demonstrating how legal protections can be undermined by problematic caveats. 45. Hartford's Sunday Kiss Ban. Hartford, Connecticut prohibits husbands from kissing their wives on Sundays. It's a classic blue law from puritanical times when affection took a mandatory day off for the Lord. The idea that a simple kiss could once be criminal on Sunday feels like dystopian satire. Imagine needing legal counsel just to smooch after brunch. Your Sunday morning routine subject to governmental oversight. The law reflects an era when religious authorities believed physical affection on the Sabbath was inappropriate, treating married couples' intimacy as requiring weekly suspension. While unenforced today, it remains on the books, a reminder that Connecticut once criminalized Sunday romance. Hartford's message: save your kisses for Monday through Saturday. Sunday is for being chaste and miserable. 46. Denmark's baby name bureaucracy. In Denmark, married couples naming their baby must choose from a government-approved list of roughly 7,000 names. Want something creative like banana or laser? You'll need permission from both the government and the church. It's bureaucratic firewall for baby names, a system where your top pick can be legally vetoed by people who've never met your kid. The list aims to protect children from ridiculous names, but it also restricts parental creativity, treating naming as a privilege requiring official approval. Denmark prioritizes societal naming standards over individual choice, suggesting that parents can't be trusted with full autonomy in naming their offspring. Your baby's identity requires governmental sign-off, turning parenthood's first major decision into an administrative approval process. 47. Japan's mandatory surname unity. Japan legally requires married couples to share the same last name, and over 96% of the time, it's the woman who surrenders her surname. This Meiji-era law is seen by many as gender inequality symbol, forcing women to sacrifice part of their identity upon marriage. While other countries have similar traditions, Japan stands nearly alone among developed nations in making it a strict legal requirement rather than cultural custom. The law eliminates the option for couples to retain separate surnames, mandating unity through female sacrifice. It's legislation that treats women's identities as expendable, positioning marriage as requiring women to literally change who they are. Japan's matrimonial code. Your marriage certificate comes with mandatory female identity erasure. 48. UK's Royal Fidelity Treason Law. In the United Kingdom, violating a member of the royal family sexually constitutes treason. The Treason Act of 1351 makes it a capital offense to sleep with the monarch's spouse, their eldest unmarried daughter, or the heir's wife. While the death penalty has been abolished, the law itself remains active, protecting royal spouses' fidelity through one of the nation's most severe legal frameworks. If you marry into the royal family, your spouse's fidelity is safeguarded by treason law. Cheating on them isn't just adultery, it's a crime against the state itself. It's legislation that treats royal marriage as national security issue, where bedroom betrayals become governmental concerns. The UK elevated royal cuckolding to treason, suggesting that some marriages matter more than others to national integrity. 49. New Jersey's common scold prosecution. Until 1972, and even later in some places, New Jersey could prosecute people as common scolds, an indictable offense aimed almost exclusively at women deemed too argumentative or naggy. The state literally gave itself power to police the tone of marital disagreements, treating a wife's complaints as potential criminal behavior. Imagine the government trying to legally define the threshold for nagging, establishing courtroom standards for when domestic criticism crosses into prosecutable territory. It's the ultimate legislative overreach, turning petty household arguments into matters for judicial intervention. The law positioned female assertiveness as criminal disruption, giving husbands state-backed authority to silence wives through legal threats. New Jersey's message: keep your voice down or face indictment. 50. The verdict: Utah's after 65 cousin marriage. For the most mind-bendingly specific marriage law on this list, the award goes to Utah's rule allowing first cousins to marry only after age 65. It's morbidly pragmatic. The government essentially said, "We'll allow this questionable union, but only after you're both too old for genetic shenanigans." The state drew an arbitrary line at 65, deciding that age makes questionable genealogy acceptable. It's not romantic flexibility, it's bureaucratic risk assessment applied to your family tree. The alternative, both parties over 55 with certified infertility, reinforces that this is purely reproductive math, not moral judgment. Utah looked at cousin marriage, checked actuarial tables, and declared, post-retirement is fine. It's governance that treats your love life like an insurance policy, calculating risk and setting age-based parameters for legally acceptable incest-adjacent relationships. And there you have it, 50 exhibits proving that when governments try to legislate love, the results are often more bizarre than any romantic comedy. From marrying the dead to requiring crow-hunting qualifications, it's clear that bureaucracy and romance make absolutely terrible bedfellows. These laws remind us that behind every seemingly normal marriage exists a framework of regulations, ranging from protective to absurd, from antiquated to actively harmful. Some safeguard vulnerable parties, others criminalize Sunday kisses or regulate garlic breath. Together, they form a monument to humanity's bizarre need to control the most intimate of human bonds through governmental oversight. What's the strangest marriage law where you live? The answer might be more disturbing than you think.